Building upon the previous section's discussion of the duty to disclose material facts to all parties, we now turn to a critical aspect of that obligation: the requirement for a licensee to disclose all known information regarding a buyer's ability to perform under the terms of a contract. In Arizona real estate, the ability of a buyer to perform, meaning their capacity to complete the transaction according to the agreed upon terms, is considered a material fact that must be disclosed to all relevant parties. This duty is essential because a real estate transaction depends not just on the willingness of the parties, but also on their financial and legal capacity to fulfill the agreement. Under Commissioner's Rule R4-28-1101A, a licensee must deal fairly and honestly with all parties in a transaction. This includes disclosing any facts known to the licensee that materially affect a party's ability to meet contractual obligations. When representing a buyer, the licensee has a duty to verify, to the extent reasonably possible, the buyer's financial qualifications before submitting an offer. This ensures that the licensee does not mislead the seller or create false expectations about the likelihood of a successful closing. In practical terms, a licensee representing a buyer must disclose if they know the buyer lacks the financial means or loan approval necessary to complete the purchase. For instance, if a buyer has not yet secured pre-qualification, or if their loan approval is contingent on selling another property, this information must be disclosed to the seller or the listing broker. Concealing such facts would constitute misrepresentation under ARS Section 32-2153A3 and could lead to disciplinary action from the Arizona Department of Real Estate, ADRE. Consider the following example. A buyer's agent submits an offer on a home while knowing that their client has not yet received a loan commitment. The buyer assures the agent that financing will probably come through, but the agent does not confirm this information. If the offer is accepted and later falls through because financing was denied, the seller could claim that the agent's failure to disclose the buyer's lack of readiness was a material omission. The ADRE would likely find the licensee in violation of their duty to deal fairly with all parties and could impose fines, suspension, or mandatory education as corrective action. The case of Lombardo v. Albu, 1996, provides insight into this principle. The Arizona Court of Appeals reaffirmed that a licensee's duty of fairness and honesty requires the disclosure of all material facts that could affect the transaction, including the financial status of the buyer if known to the agent. Although confidentiality and loyalty are owed to the client, they do not permit concealment of information that materially affects another party's rights under the contract. In essence, a licensee cannot allow the desire to protect a client's privacy to override their duty to maintain honesty and integrity in the transaction. Additionally, the Arizona Association of Realtors Residential Resale Real Estate Purchase Contract, often called the AAR Purchase Contract, requires buyers to provide a loan status update, LSU, to the seller within 5 days of contract acceptance. Unless otherwise stated, the buyer's agent is responsible for ensuring that this form is accurate and timely. If a licensee becomes aware that the buyer's financing status has changed, such as a job loss, debt increase, or loan denial, they must disclose that change immediately, as it directly impacts the buyer's ability to perform. This duty also applies when a buyer intends to make a cash purchase. A licensee must verify that funds are available and not encumbered by other obligations before representing to the seller that the buyer can close without financing. For example, if the buyer claims to have sufficient cash in an investment account, but those funds are subject to a pending lawsuit or cannot be liquidated in time, the agent must disclose that limitation. Failure to do so could result in contract disputes and potential claims of misrepresentation. Disclosure of a buyer's ability to perform also extends to contingent transactions. If a buyer's offer is contingent on selling another property, that fact must be disclosed to the seller. Even if the buyer's current home is under contract, the licensee must disclose the contingency because there is always a possibility that the sale will not close. In this situation, honesty ensures that the seller can make an informed decision about accepting the offer and possibly seeking backup buyers. It is equally important to understand the limitations of disclosure. While a licensee must disclose known material facts, they are not expected to independently verify information that they have no reason to doubt. For example, if a lender provides a pre-qualification letter confirming the buyer's financing status, the agent may rely on that documentation unless they become aware of contradictory information. However, if the buyer later confides that their credit score dropped or that they were denied final approval, the agent is legally obligated to disclose that fact. The balance between client confidentiality and disclosure is sometimes challenging. While a licensee may not reveal personal financial details unnecessarily, they must always disclose whether those details impact the buyer's ability to close. For instance, if a buyer tells their agent they lost their job but instructs the agent not to tell the seller, the agent must still disclose that the buyer is no longer financially qualified to complete the transaction. Confidentiality cannot be used to conceal material facts affecting another party's contractual rights. Review summary. The duty to disclose a buyer's ability to perform is a cornerstone of honest dealing in Arizona real estate. Under R4-28-1101A and ARS Section 32-2153A3, a licensee must disclose any known information that materially affects a buyer's capacity to fulfill a contract, including financial qualifications, loan status, or contingencies. Court cases such as Lombardo v. Albu reinforce that fairness and integrity require full transparency. When a buyer's ability to perform is uncertain, concealment of financing issues can result in contract cancellations, disputes, and disciplinary action by ADRI. Discussion. Why must a licensee disclose a buyer's inability to secure financing, even if it may harm the buyer's bargaining position? Answer. Because R4-28-1101A requires licensees to deal fairly and honestly with all parties, and concealing financing problems is a material omission that misleads the seller. If a buyer's loan is contingent on selling another property, what must the agent do? Answer. The agent must disclose the contingency to the seller, as it directly affects the buyer's ability to perform under the purchase contract. If a licensee learns that a buyer's financial situation changed after contract acceptance, what should they do? Answer. They must immediately disclose the change to the seller or listing broker, as required by both the AAR purchase contract and R4-28-1101A. Closing remarks. Transparency about a buyer's ability to perform is not merely a procedural step. It is a measure of professionalism and ethical conduct. Real estate licensees serve as intermediaries of trust, and the accuracy of their disclosures can determine the success or failure of a transaction. Upholding this obligation ensures that all parties operate with realistic expectations and that the transaction proceeds with fairness and integrity. By diligently disclosing any known issues that affect a buyer's capacity to perform, a licensee not only complies with Arizona law, but also protects their reputation and the stability of the real estate marketplace.